So, how did sending an email end up with a solicitor paying a £50,000 fine and £260,000 in costs? Well, let me explain. This all starts with, remember Nadim Zahawi? He was the former Chancellor of the Exchequer. And a chap called Dan Needle, who heads a group called Tax Policy Associates or something. They investigate dubious tax practices, to put it mildly and hopefully non-defamatory. And he commented and said, look, this is a guy whose own tax affairs are very, very dubious. And really, is this the person who should be in charge of the economy of the United Kingdom? Now, Mr. Zahawi did not take this lying down, and he instructed solicitors to bring a defamation claim about this. I mean, just to cut to the chase with regards to the defamation claim, notwithstanding all his denials that there's nothing wrong with my sort of tax affairs, etc., etc., it turned out in the background that he owed £3 million in back tax, and he did some deal with the revenue. And he was actually doing the deal at the time that Dan Needle was publicising all this. He was actually doing some deal in the background to sort that out. So obviously a defamation claim actually probably wouldn't have had much of a chance, for all sorts of reasons, not including the fact that it appears that Mr. Needle's comments, whether they were opinion or a statement on a matter of public interest, they were also probably true. But anyway, the lawyer, and it was actually a lawyer called Ashley Simon Hurst, who worked for this firm, he had an email sent to Dan Needle, and it was headed confidential and without prejudice, and it threatened a defamation claim. But it also said, it is up to you whether you respond to this email, but you are not entitled to publish it or refer to it other than for purposes of seeking legal advice. That would be a serious matter, as you know. Okay. Dan Needle responded and said, I'm not going to accept any without prejudice correspondence, and I reserve the right to publish what I want. There was the letter before claim came out, and that again actually said, look, if your purpose of saying you won't accept without prejudice correspondence is that you intend to publish all this, that would be improper. And we request you do not do that. So notice there, that's a request, and it doesn't hint that there would be some sort of consequence of it. But anyway, this matter duly found its way to the Solicitors Regulation Authority. That's the body, a bit like the Bar Standards Board for us, that regulates the conduct of solicitors. And they took this very, very seriously. And they brought proceedings, effectively prosecuted Mr. Hurst. So that went before something called the Solicitors Disciplinary Tribunal. It's a bit like how the Bar Standards Board works. That's our regulator, and if we commit sort of minor infractions, the BSB can deal with it, and so can the SRA. But if it's a sort of serious allegation, it effectively goes off for, quotes, trial in front of the SDT, which is an independent body. So you get like a 3-person panel. And what they said was, well, this is just not correct. This is a misuse of the term without prejudice. It's also a misuse of, how confidence works. And effectively, it was a threat and an intimidation. And it amounted to a slap, a strategic litigation against public participation. And we've just had the hearing this week, and they actually live streamed it. So I was able to actually watch it, not all of it, because I was just sort of pretending to do work at the same time and sort of had the headphones in and listening to this and getting distracted. But it was very, very interesting in how it worked. So the argument was, this is completely improper, because don't forget, notwithstanding the fact that Dan Needle is eminently qualified, he's effectively, for these purposes, a layperson. So this was a letter to a layperson. And what the SRA said is, well, look, this was clearly an attempt to intimidate, and also you've misled somebody, because there is nothing whatsoever to stop anybody publishing correspondence they receive in terms of threats of litigation, subject to a couple of exceptions, which I'll come on to and just cover very, very briefly. But those were the charges. So first of all, what does without prejudice mean? Without prejudice is a term that we use when we want to try and settle a matter. And the way it works is, to encourage settlement, what the court says is, look, whatever's going on in public with all the proper pleadings, like, you send your letter before action, which is obviously a public document that the judge is entitled to read, because that sets out your claim, and that gives people a chance to sort of respond initially. And particulars of claim, that's the formal procedure saying this is what we say you did wrong, and all that sort of thing. That all goes before the judge. The judge can see that. But let's say you just want to settle something. So in public you're going, we are suing you and we want all this money and you've been terrible, and the defence is, this is all lies and we've done nothing wrong and we will defend this vigorously. Either side can say, well, look, we will accept this to go away and drop the case. Or the defendant can say, how about if I do pay you this and I do this, this and that, you discontinue. Because, obviously, as I've said before, 97% of issued claims, that's a claim where somebody's gone to the trouble of actually paying the issue fee and drafting all the particulars of claim, etc., they settle before, they get to trial. Because, once, people can see what the argument is, and we've got a very front-loaded approach to litigation in this country, which does make things very expensive up front, but it's a cards-on-the-table approach. The idea is, look, you don't spring any surprises on people. It's not like Perry Mason, where you sort of find everything out in cross-examination and you suddenly, I'll call one of my surprise witnesses, each more surprising than the last. It's if everybody puts their cards on the table and then has proper legal advice, you can usually predict what's going to happen to a certain degree, and it just makes things quicker. But without prejudice, it's a collaborative thing. You have to agree between yourselves that, this stuff's on without prejudice basis. And we do that all the time on phone calls. I'll, be instructed in a matter and I'll send off the formal sort of threatening thing initially going, oh, this is outrageous and we're going to do this and, we're going to sue you and all that sort of thing and this is what we want. But then I'll just ring the solicitor and we'll be chatting away and we'll sort of, like, this is on a without prejudice basis? Yeah, sure. And the idea is you can be very open about this. Because nobody can use this in court then. You can't sort of turn up to the trial and say, well, actually, they're all denying this claim now, but they sent us a letter saying they would actually, pay us £50,000 instead of the £100,000 we're asking. So clearly that's an admission that they did it or they accept they're wrong. It's like, well, no, you can't put that in. And without prejudice is very, very strong. People have tried to get around it saying, well, you've admitted things in here that you're now denying in court, so therefore we should be allowed to refer to it. And so long as you're not sort of using the without prejudice, you couldn't sort of write a letter and saying, haha, I confess to all those murders on a without prejudice basis. But generally speaking, if you're trying to settle it without prejudice, we would normally mark the correspondence without prejudice, and we usually add savers to costs, because once the hearing is over, then you can actually show all this material to the judge and say, well, look, you have now found for the defendant and you've awarded them £50,000 damages. But back like 2 years ago, we offered them £60,000 to go away on this. Therefore, they haven't beaten our offer and this trial was completely unnecessary. So even though we've technically lost and the usual rule is loser pays, winner's costs, this was all avoidable if they've accepted our offer, and vice versa. The claimants can come in and, I mean, it's different for the claimants, if they're successful, because, they'd get their costs anyway. But they can sort of say, well, look, we were willing to walk away with a lot less than we've won. So when it comes to assessing our costs and whether our costs were reasonable, proportional and necessary, you might want to bear that in mind. But in this particular case, they said this is a misuse of the without prejudice stuff, because it wasn't without prejudice. You didn't make any offers. You just said, we are going to sue you unless you stop talking about this and don't sort of speak about our client again. There wasn't an offer there. And they said, similarly, you can't say something is confidential, unilaterally. The other side has to agree. I mean, sometimes confidence can arise by circumstance. You have duties of confidence. In an employment context, for instance, there's always been the thing about you can't reveal trade secrets or corporate secrets or sensitive commercial information. But that'll usually actually be in your terms and conditions anyway. So it's a contractual duty. But generally speaking, agreeing confidence, it's something that you have to accept and say, I agree that this is a confidential dealing. And you might do that. We say, we do non-disclosure agreements a lot when we're discussing business opportunities and things. I'll do that where, for clients where there'll be a meeting about, possible buying businesses or taking over businesses or investing, and everybody needs to share, we need to see the financials. So we'll do a non-disclosure agreement saying, do we all agree that obviously, so we can be very open and frank in our discussions about, this matter. Everybody can sort of produce all their secret documents and their confidential financial information, but we agree that we won't tell anybody else about it. And if this deal collapses or doesn't go any further, we all keep stum for future. So that's fine. But in this particular case, they said, no, this was just an abuse of, without prejudice and confidentiality. And they actually found the allegation proven in relation to the email. Interestingly, though, they said the letter didn't quite cross the line, because although it was perhaps pushing it a little bit far, saying you shouldn't really be doing this and it's improper, it didn't suggest that it was actually wrong to do it, that there would be a sanction. Because, the email threatened and said, well, you'll be in trouble if you do this. And it's like, well, no, you won't. And that is misusing your position as a lawyer, because you are suggesting something, legal consequences, when there is no basis to do so, because there's no truth in that. So, after the hearing, and they did it really quickly, what I find interesting is they had the hearing, they had all the evidence, then they retired for a bit, and then they came back and gave their decision straight away, which is why I don't have a written judgment. So I'm just working from the skeleton arguments to remind me who was who. And then once they'd found that, then they also said, okay, now we need to consider the sanction and the costs. So people made their submissions about what they thought the sanction should be. Mainly it was on Mr. Hurst's lawyers to sort of argue down, because it's a bit like in criminal proceedings where the prosecution don't agitate for any particular sentence. They can advise the judge as to the sentencing guidelines and suggest where they think the offending lies within those guidelines, but they don't, advocate and say, we think you should sentence to this. They just say, this is the range of things you can sentence on, and this is the stuff you should refer to. But the defence can say, yes, well, we think it should be a much lower penalty than what, and this is why. So they did the mitigation, and when it came to the costs, they said, we accept that we have to pay the costs. It's about like, my friend Charlotte, where, generally speaking, in a regulatory thing, if you lose, you have to pay the regulator's costs of the prosecution. But if you were acquitted, then generally it's no order as to costs, because the argument is the regulator has a public duty to bring these cases, so they shouldn't be penalised for doing their job. And it's going to be very interesting to see what happens with Charlotte's case there, bearing in mind that she succeeded there because before it even got to the full hearing, they said, oh, there's no case to answer. We don't need to hear any evidence on this. We've just looked at what the charge is and what the offending tweets are, and we don't say they crossed the line. But in this, they said, the email has crossed the line, the letter hasn't. So Mr. Hurst's lawyer said, well, we argue then we should get a 25% discount because they didn't succeed on everything. And also they tried to argue down a little bit on the hours. But I didn't quite catch, because it was a live hearing, I didn't quite catch what the full schedule of costs was. But the fact that in the end they said, you're going to pay £260,000 costs. Well, there must have been in excess of £300,000, which just shows how expensive these are. In fairness, they said a lot of that, because the actual Mr. Hurst costs were even higher. And it's interesting that the paragraph 1 of the skeleton argument says the applicant's case, the applicant being the SRA, says, this application is far more straightforward than the voluminous documentation and authorities suggest. I mean, they said you over-defended this. But yeah, so they were awarded their £260,000 costs. And when it came to sanction, they said, well, we think this warrants about a £50,000 fine. So he's been ordered to pay a fine of £50,000. So that's £310,000. And this was brought against him personally. It wasn't the firm, it was the actual lawyer. So this just goes to show how careful you have to be. And this also shows this issue where, yes, you have to go with your client's instructions, but ultimately lawyers have total responsibility and total say over how the case is presented. And if you're not happy with that, you can part company with your lawyers, but you can't insist that we correspond in a particular way. Oh, I want you to be harder about that. I want you to be more fiery. I mean, some lawyers are like that, and you have different people. I used to work for there's some in-house stuff for a firm, and their unofficial motto was, nobody likes us and we don't care, because they specialised in, hardcore, we are very aggressive litigators, and we won't be sort of, settling your course with our friends from the opposing firm, you know, when we go play golf next Sunday. It was like, no, we'll go out there and fight your corner and we'll be all hyper-aggressive. But the courts do try to discourage that. And people have been sanctioned in terms of costs where they said, you know, your correspondence was so aggressive and so forceful, and it just, you know, it made it impossible for anybody to settle because you just kept turning the heat up. So actually, I'm a big fan of, I am notoriously a very gentle litigator. I mean, when people, I always write everything knowing that one day a judge might read it. So I always like to be the, hey, you know, hi. I use first names quite often in informal correspondence. Let's go sort this out. Let's do this. I'm sure we can work this with a bit of goodwill on both sides, etc., etc. And that often, that actually encourages people to settle. There's nothing better for your case than if you're opposing the lawyers on the other side are as reasonable as your own, you know, like lawyers. Because people will do deals then. People will settle things because it's not like we have an invested interest. Obviously, we want to do our best for the client. But first of all, we're not going to sacrifice our careers like this chap nearly did. But also, it's just counterproductive just turning the heat up a lot of the time. If you want a result, that is. I mean, sometimes people do go, no, I just want to cause problems for these people. I want to be aggressive. I want to scare them. And in this particular case, it was very interesting where they were discussing the tactics. And then, you know, Mr. Hurst was cross-examined, and they said, isn't it true that effectively, you know, you want to scare people off and you want to shut people up? And he said, well, yeah, that's the whole point of reputation management. We want to get the best result for our client, and sometimes the threat of defamation proceedings is part of that. But what they're saying is we should only bring the threat of defamation proceedings if fundamentally there's a legitimate case to answer there. You know, there is a legitimate cause of action. We can't just threaten proceedings when we know that there's no actual basis for them and there's no chance of them succeeding. You know, that's the definition of a slap. Although interestingly, the SDT, the tribunal, seemed to suggest that actually we don't think this crosses the line into a slap, because at the time and on your instructions, arguably there was a potential defamation case there. So we're not going to suggest that you did this knowing there wasn't a defamation case. I mean, now we know from Mr. Z's behaviour that actually a defamation case wouldn't have succeeded, but it seems that arguably he may have, you know, I won't say misled his lawyers, but his lawyers may have thought the case was a lot stronger than it actually was. So they didn't criticise him for, you know, acting and intimating they would bring a defamation claim. They just said it's the way that you did it that crossed the threshold. So there you go. A salutary warning to everybody. And this is something to remember if you yourself are ever sued or anything like that. Generally speaking, if somebody threatens you and says you can't discuss this, yes, you can. Subject to, I mean, for instance, if it was family proceedings, there may be confidential stuff in there, like the names of children and things like that. And also in some commercial dealings, you might have to refer to sort of confidential matters, you know, like I say, you know, arrangements that were dealt with a non-disclosure agreement in place. So that would be one exception. It's not a blanket rule. And like I said at the beginning, there can be some exceptions to this. But generally speaking, if you're just bringing a claim that will be heard in public, then what you can't do is say, no, you can't talk about this. So there you go. As always, hope you found that vaguely useful, vaguely informative, vaguely accurate. I'll go sit on the other side to do my stuff. Thank you for all your comments about the thumbnails. Yes, because I have been asking Dan to do my thumbnails. So I like that one. And I know it's a bit annoying with all the sort of clickbaity stuff. But the reason I do it, I mean, like I said, I've never been one for sort of saying, please like and subscribe. I mean, don't get me wrong, if you want to, I'm more than grateful. But I'm just, you know, happy when you actually watch these blooming videos. But the weird thing is, because somebody said, one of the comments, I thought it was a legit comment, they said, I had to click on the video to find out what it was about. And the weird thing is, that's how the algorithm works. If I do my old style thumbnails, where I sort of just basically say, this is a video about the CPR, or this is a video about this, YouTube doesn't seem to like that. Your YouTube partners, if you get on this, they always say that the best way to promote things is you should do curiosity plus fear or curiosity plus desire. So I need to intrigue you and scare you a little bit, or intrigue you and think, oh wow, maybe I'll get rich. I should start doing Bitcoin. Should we do a Lord Loverduck and Capybarister meme coin or something? Like that lass who did that Hawk Chewer lass who released the meme coin, and everybody's like complaining, I deposited my life savings to invest in this thing for some girl who had a 15 minutes of fame because of one interview. Imagine my surprise when I lost all my money. But yeah, maybe we should do that. But give us your thoughts in the comments, both about this topic generally, and, you know, like say, lawyers behaving badly and over-aggressive litigation. I mean, do you think this was right, the right decision? Or do you think maybe you should be allowed to go all gung-ho? But I'm also interested in your comments about sort of thumbnails and titles and stuff like that. I mean, if I was the sort of person who ever thought ahead, which I'm not, I could always say my next video is going to be about X, Y, and Z. Please suggest some thumbnails. But there you go.